Good morning.
Good morning, Judge.
Deja, we have, it's two of them that we need interpretation for.
And who are they, Mary?
The other one, the one that I sent you, and the other one's last name is Perez, I believe.
Okay, I have him.
Okay,
Yes, thank you.
you're welcome.
And Miss Mary, I didn't write those names down. Is it Gonzalez Canales? Is that one? Let me see.
The ones that I have that Miss Mary sent me, Judge, is Mateo. I'm sorry. Yes, Mateo Segura. And Perez Diaz.
Let's see. Mateo Segura and
Perez Diaz.
Paris Diaz.
I have two other names on the list, but I don't know if they're going to need my assistance.
Yeah, it's just the two that I sent you in the email.
Okay.
Okay.
Thank you.
And is that Perez and Mateus Segura?
Yes, Your Honor.
Okay. I saw.
And please understand, we're continuing, well, there's an issue with Gates, and then the fugitive Honeycutt, we're continuing. Shh.
That's going to be my understanding, because with Honeycutt, only it wasn't Honeycutt. There's another person we didn't get information on. So are we going to continue Honeycutt?
It was my understanding we are. We're gonna put you-
Okay. And for some reason,
I'm sorry for the background noise.
no, that's fine. That's fine. So we have Diaz, Perez, and Mateo Segura. Are those the only individuals that need the services of the interpreter today?
Yes, Your Honor.
Okay. So let's bring up Mr. Perez. Well, Mr. Mateo Segura and Mr. Perez. Let's deal with them first. Okay, Mr. Mateo Segura, would you raise your hand, please?
Señor Mateo Segura, ¿podría usted levantar su mano, por favor?
And Mr. Perez,
Y el señor Pérez,
hand.
¿podría levantar su mano?
Okay. Can the two of you both hear and understand the interpreter?
¿Pueden ustedes dos escuchar y entender a la intérprete?
Sí.
Yes, yes.
Mr. Mateo Segura, sir, you've been charged with 1 count of robbery.
Señor Mateo Segura, a usted se le acusa de un cargo de asalto.
I've set a bond at $5,000.
Yo le fijé una fianza de $5,000.
This is a felony offense.
Este es un delito grave.
Your preliminary hearing date is going to be set for July 25th at 8:30 in the morning.
Su audiencia preliminar va a ser programada para el día 25 de julio a las 8:30 de la mañana.
The next statement I'm going to make is for the benefit of both Mr. Mateo Segura and Mr. Perez. You can translate that, Miss.
La próxima declaración. I'm sorry, Judge. Were you able to hear me?
I heard part of it.
Okay, I'll repeat it. La próxima declaración que voy a dar va a ser para el beneficio de los dos, del señor Mateo Segura y del señor Pérez.
The purpose of this proceeding is not to determine your guilt or innocence or to have a trial in your case.
El propósito de este proceso no es determinar su culpabilidad o su inocencia o de tener un juicio en su caso.
I'm here to tell you what you're charged with and to appoint a lawyer to represent you.
Yo estoy acá para decirle de lo que se le acusa y para nombrarle un abogado para que lo represente.
I'm also here to give you your next court date.
Estoy acá también para decirle cuándo va a ser su próxima corte.
And in your case, Mr. Mateo Segura, your next court date is going to be for July 25th at 8:30 in the morning.
Y en su caso, señor Mateo Segura, su próxima corte va a ser el día 25 de julio a las 8:30 de la mañana.
If you want me to appoint you a lawyer, I can. Do you want me to appoint you a lawyer, Mr. Mateo Segura?
Si usted quiere que yo le nombre un abogado, señor Mateo Segura, yo se lo podría nombrar. ¿Quiere usted que yo le nombre un abogado, señor Mateo Segura?
Pues, a lo que veo, yo necesito un abogado porque a mí no me han dejado ni siquiera explicar nada de lo sucedido en ningún momento.
I think I need an attorney because they have not allowed me to explain anything of what happened at any time.
And in your case, sir, I do understand your statement. There appears to be some ambiguity in the narrative of what happened.
Y en su caso, señor, yo entiendo que existe algún tipo de ambigüedad en la narrativa de lo que ocurrió.
No entiendo cómo un tipo de ambigüedad. ¿A qué se refiere?
I don't understand what do you mean by ambiguity.
You're charged with robbery,
A
but
usted se le acusa de asalto,
there appears to be a dispute between you and a taxi driver.
pero aparentemente hay una disputa entre usted y el taxista.
Eso, hay un malentendido en eso. Yo soy el despache de la base. Yo soy el taxista prácticamente.
There was a misunderstanding. I was the dispatcher of the base. I was basically the taxi cab driver.
Cuando una persona pidió un servicio de taxi, una joven, cuando yo mandé al servicio, la muchacha pasó a recoger a su casa de él al muchacho.
Espérese un momentito. Una persona, repítame porque se estaba cortando la comunicación.
Okay, una señorita llamó para un servicio de taxi.
Okay, a young lady called for a taxi cab driver service.
Cuando yo mandé la unidad a levantarla a ella,
And when I sent the unit to pick her up,
ella le dijo que iban a pasar por la casa de él a buscarlo para luego ir a un hotel, Motel 6 en La Tara.
she told them that they were going to go to his house to pick him up to go to a Motel 6 on Tara.
Okay, let
Okay.
me stop. Right
Déjeme
now.
pararlo.
I don't want Mr. Mateo Segura to say anything more.
Yo no quiero que el señor Mateo Segura diga nada más.
He may have a defense to this case, but he's going to need a lawyer. And I'm perfectly willing to appoint him a lawyer.
Él puede ser que tenga una defensa para este caso, pero él va a necesitar un abogado y yo estoy dispuesto a nombrarle un abogado.
Okay.
Okay.
I'm going to appoint you a lawyer to represent you.
Yo le voy a nombrar un abogado para que lo represente.
You need to speak to the lawyer about the facts of this case.
Y usted necesita hablar con el abogado con respecto a los detalles de este caso.
You're going to be able to bond out today.
Usted va a poder pagar su fianza y salir en el día de hoy.
And in speaking to the lawyer, maybe the lawyer can get this charge dropped.
Y cuando hable con su abogado, quizás su abogado puede conseguir que le desestimen o que le quiten este cargo.
Your preliminary hearing date is going to be set for July 26th at 8:30 in the morning.
Su audiencia preliminar va a estar programada para el día 25 de julio a las 8:30 de la mañana.
That date will get waived upon your bonding out.
Y esa audiencia se cancela tan pronto usted pague su fianza y salga.
And you will receive a new court date in the mail.
Y usted va a recibir un nuevo citatorio por correo.
Do you have any questions of me, Mr. Mateo Segura?
¿Tiene usted alguna pregunta para mí, señor Mateo Segura?
El 25 de julio yo tengo esa audiencia,
On July 25th, I have a hearing.
pero si yo pago la fianza que se me está imponiendo, yo salgo hoy entonces. Y esa audiencia,
But if I pay the bond that you said, then I can get out today.
Yes,
Sí,
but you will not have a hearing on July 26th.
entonces en ese caso usted no tendría la audiencia del día 25 de julio.
Your case will get transferred to the state court of Clayton County and assigned to a judge who I do not know what judge your case will be assigned to.
Su caso sería transferido al Tribunal Estatal del Condado de Clayton y sería asignado a un juez, pero yo no sé cuál juez sería al cual su caso le sería asignado.
And that's why I can't tell you what the next court date will be upon your bonding out.
Y esa es la razón por la que yo no le puedo decir cuándo su próxima corte va a ser después que usted pague su fianza y salga.
esto es bien injusto, yo siento eso. Yo estaba trabajando.
I think everything is just very unfair. I was working.
Yo estaba trabajando y ahora me acusa que yo estaba saltando.
I was working and now I'm being accused of robbery.
Ellos fue que no quisieron pagar, que no tenían dinero para pagar el taxi.
They were the one who didn't have the money to pay for the taxi.
No. Sí, tenía.
Mr. Mateo Segura,
Señor Mateo Segura,
Yes.
you can talk to me for the next 5 hours about what has happened to you, and it will do you no good.
usted puede hablar conmigo por las próximas 5 horas con respecto a lo que le ha sucedido, pero esto no le va a beneficiar a usted.
I've appointed a lawyer to represent you.
Yo le he nombrado un abogado para que lo represente.
That is the person that you should be speaking to.
Y esa es la persona con la que usted debe de estar hablando.
I'm not the officer that arrested you.
Yo no soy el agente que lo arrestó.
Therefore, I cannot unarrest you.
O sea, que por esta razón yo no lo puedo desarrestar.
Do you understand that, sir?
¿Entiende usted esto, señor?
Sí.
Yes.
Okay. Mr. Perez,
Ok, señor Pérez.
Mr. Mateo Seguro can go back.
El señor Mateo Segura puede retirarse.
Mr. Perez, can you hear and understand the interpreter?
Señor Pérez, ¿puede usted escuchar y entender al intérprete?
Okay. ¿Sí escucho?
Yes, I can hear.
Sir, you're charged with one count of theft of services as a misdemeanor.
Señora, usted se le acusa de un cargo de robo de servicios como un delito menor.
No, yo lo expliqué al taxi de la señora.
No, I explained to the taxi and to the lady.
Sí, no, el taxi yo lo dije que me espere.
I told the taxi to wait for me.
Sí, y yo dije, espérame, ahorita te lo pago.
I told him, wait, and I'll pay you in a little bit.
Mr. Perez,
Señor Pérez,
would you like for me to appoint a lawyer to represent you?
¿le gustaría a usted que yo le nombre un abogado para que lo represente?
Sí,
Yes.
I'm going to appoint a lawyer to represent you.
Yo le voy a nombrar un abogado para que lo represente.
The lawyer is the person that you need to tell this story to.
El abogado es la persona a la cual usted necesita contarle su versión de los hechos.
I cannot do anything at this point as it relates to the facts of this case.
Yo no puedo hacer nada en estos momentos con relación a cómo ocurrieron los hechos,
This is not a trial.
porque este no es un juicio.
I am only here to tell you that you have a bond that's been set at $2,000.
Yo solamente estoy acá para decirle que su fianza le ha sido fijada a $2,000.
Your next court date will be July 26th at 8:30 in the morning.
Su próxima corte va a ser el día 26 de julio a las 8:30 de la mañana.
If you post bond, that court date will get waived and you will receive a new court date in the mail.
Si usted paga su fianza, esa corte se cancela y usted recibiría un nuevo citatorio por correo.
ok, está bien, sí, sí lo pago.
Okay, that's fine. I'll pay it.
Do you have any questions for me, sir?
¿Tiene usted alguna pregunta para mí, señor?
Sí, mira. Bueno, lo que pasa, yo el taxi no es que no quiera pagarlo.
Yes, the thing is that it's not that I don't want to pay for the taxi.
No es por eso que no quiero pagarlo. Lo que pasa es que me espera el taxi.
It's not that I didn't want to pay it. It's just that I asked him to wait for me.
Okay, sir, that's talking about the facts of your case.
Ok, señor, usted está hablando de cómo ocurrieron los hechos.
And
Sí.
this is not the time to speak about the facts of your case.
Y este no es el momento para que usted hable de cómo ocurrieron los hechos.
I've appointed a lawyer to represent you.
Yo le nombré un abogado para que lo represente.
Speak to the lawyer about the facts of your case so that the lawyer can assist you.
Hable con su abogado con respecto a los detalles de su caso para que el abogado le pueda ayudar.
Ok.
Ok,
All right, sir, you're free to go back.
ok, señor, puede retirarse.
Ok.
Ok.
So before I allow Ms. Bermudez to leave, is there anybody else that needs the services of the interpreter?
No, Your Honor, not on the mail side.
No, Your
Okay.
Honor, none on the female side either.
Okay, thank you. Ms. Bermudez, you're excused. Have a good day.
Yes, sir. You have a good day as well.
All right. So let's try to get this train rolling. I'm sorry, I'm looking at the chat. My eyes are not as good as they used to be. Oh, wow.
Everything okay, Judge?
Yeah, I'm just it's my bad eyes. On the ladies' side, which two female inmates have bonded out?
Your Honor, there's only one. It's Baxter.
Baxter, yes. She can be released and go through the bonding process.
Thank you, Your Honor.
All right. Well, it says two. But I'm
Your Honor,
reading.
there was another female in here, but she's not part of the first appearance.
Oh, okay. Was that Honeycutt?
Oh, Your Honor, she's here.
So, okay. All right. So, Miss Baxter, we're going to officially designate her as OTB. And now for everyone else. This is the first appearance hearing for the Magistrate Court of Clayton County. My name is Brad Gardner. I'm going to be presiding over the calendar here today. We're not here to have a trial of your case or to take a plea in your case. We're here for me to tell you what you've been charged with, to set bond, and to appoint a lawyer if you qualify. During this and all other proceedings, you're going to have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, testify on your own behalf, or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Most of you will all have bonds. Those bonds may be satisfied by cash, commercial, or property. Some of you will have special conditions on your bond. They will prohibit you from going to certain places or being around certain people. If you violate the court's order as it relates to the prohibition on your bond, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bond today. In that event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you're currently on active probation, this court is not authorized to set bond in your case. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, I need everyone to raise your right hand, please. Do you swear or affirm that any statement you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes, sir.
Okay, let's begin on the ladies' side with Miss Guzman. Are you, is it Hadazari Guzman?
Yes, sir, it is.
Ma'am, you're charged with one count of giving a false statement. The bond is going to be set at $3,000. They listed this as a misdemeanor, although I believe it is a felony offense. I'm going to give you a preliminary hearing date for the misdemeanor day, which is July 26th at 8:30 in the morning, courtroom 201. If you bond out, that date will get waived and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay. Okay, ma'am, I'm going to find that you qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, I don't think so.
Okay, ma'am, you are free to go back. Miss Jones, Ashley Jones. Ms. Jones, ma'am, you're charged with one count of aggravated assault. This is a felony offense. Bond is going to be set at $10,000. There's going to be a stay away provision on this bond, a stay away from a Charles E. Jones. Do you understand that, ma'am?
Yes, Your Honor.
Your preliminary hearing date is going to be set for July 25th at 8:30 in the morning, courtroom 201, but most likely it'll be by Zoom. If you bond out, that hearing will get waived and you will receive a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay. Okay, ma'am, I'm going to find that you do qualify for the appointment of lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir, Your Honor. No, I don't.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Who do we have next? Miss Lily.
Yes, Your Honor.
Miss Lily, ma'am, you've been charged one count of misdemeanor theft by taking bond set by schedule, which means it's automatically set at $2,000. You're going to have a preliminary hearing date that's going to be set for July 25th at July 26th at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. Okay, ma'am. Looks like you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me? I'm sorry, ma'am.
No.
Okay. You're free to go back. Is it Miss Wickershak?
Yes, sir, Your Honor.
Okay, ma'am, you've been charged with one count of burglary. I have questions about, well, not questions, but concerns about the way that this charge was written up. There may be issues as to whether this is an actual burglary or not. Do you have a lawyer?
My mom has one. I haven't been able to speak with her yet, but she's speaking to one right now.
Okay. So you're gonna hire your own lawyer?
Yeah.
Okay. I think you should speak to the lawyer about the facts of this case. Because it seems to make out a theft, but not necessarily a burglary. If everything is considered as true. Your preliminary hearing date is going to be set, or you have a bond of $5,000. Your preliminary hearing date is going to be set for July 25th at 8:30 in the morning.
Okay.
Upon your bonding out, that date will get waived and you'll get a new court date in the mail.
Okay.
Do you have any questions of me?
Not at all. Thank you, Your Honor.
Okay. All right, ma'am, you're free to go back. And my understanding is that Miss Honeycutt was going to be continued.
So I have Mrs. Thrasher. You can call her name, sir?
You said Thrasher?
Yes, sir, correct. LE number 1385652.
Okay. You have Thrasher. Yep.
One up, ma'am.
Clara, is it Clama?
Yes, yes, sir.
You said Clama?
Plum Thrasher, yes, sir.
Thrasher. Okay, Miss Thrasher, ma'am, you've been charged with one count of trafficking cocaine. That's a felony offense. Bond is going to be set at $10,000. Charged one count of violation of Georgia Controlled Substance Act, but that's a felony offense also. Bond is going to be set at $10,000. And you're charged with one count of obstructing or hindering the display of your license plate. Bond is going to be set at $500. So that's a total bond of $25,000.
Okay, yes, sir.
Your preliminary hearing date is going to be set for July 25th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Do you plan on hiring attorney you want me to see if you qualify?
Oh, I got my own lawyer.
You do?
Yes, sir.
Okay, do you have any questions for me?
No, sir.
Okay, ma'am, you're free to go back.
Okay, thank you.
You're welcome.
Is Honeycutt, do you want her to come up or continue till tomorrow?
We'll continue Honeycutt until tomorrow. My understanding is that there's something wrong as it relates to the fugitive information.
Yes, sir.
So I'll do a continuance order, but make certain that she's brought back tomorrow.
Yes, sir.
Thank you. Okay, let's switch over to the mail side.
Thank you, Judge.
Mr. Baker,
Yes, y'all.
give me 1 second, Mr. Baker.
Take your time, y'all.
Mr. Baker, sir, you're charged with 1 count of misdemeanor theft by shoplifting. Bond is set by schedule. If you're gonna ask me a question, I'll allow you to ask me the question at the end, okay?
Yes, I'm just waiting my rights. I wouldn't tell the truth and the untruth. I'm just waiting.
Okay. The bond's gonna be set at $2,000. Your preliminary hearing date is gonna be set for July 26th, I'm sorry, at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, Mr. Baker. I am going to appoint a lawyer to represent you. Now, is there anything that you want to tell me?
No, I won't be able to afford to make bond. Is there any way possible that I can, understand, get a case dismissed or signature bond or something like that? Because I don't have no family, you know what I'm saying? All my family, they deceased and passed, and I don't have no family, no friends or nothing.
Okay, so
On disability, I'm on disability.
okay. I have appointed a lawyer to represent you. That lawyer can do what they call a waiver to get your case over into state court. And if this is something where you intend to plead guilty to the charges, the lawyer can fast track everything. But I'm not your lawyer, so I'm not going to get in the middle of that discussion about whether you are guilty or innocent of the charges.
Correct. It's innocent.
Right. So I'm appointing a lawyer to represent you. And if this is something where it's your desire to move this along as fast as possible, you should speak to the lawyer about it so that
Early court date I can get or something like that. That's the latest court date you can give, 26.
well, what I've given you is the earliest court date that we have in magistrate court. So things are moving, and there are people that are in front of you as it relates to magistrate court. If you're talking about getting over to state court where this can be dealt with, one, I don't know what judge your case will be assigned to. Your lawyer would know.
But on
And
26th.
I don't know that judge's schedule.
Correct. On 26th, I'll be back in front of you, correct?
It will not be me, but if this is something that you're trying to get done sooner rather than later, then you need to speak to your lawyer about that.
Okay. How soon will that my lawyer come and speak to me?
Because it's a misdemeanor offense, it's going to be Lister and Holt, H-O-L-T. This private law firm that contracts with the county to take on indigent misdemeanor cases. My understanding is that because of the way that technology has moved, that when they get, I'll send them the information today.
Okay.
And that they'll try to set up a video conference with you so that they can at least have an initial conversation with you about your case and your charges.
Right.
And just tell them what you've told me, and it should lead to a
signature bond, SOB, dismiss, or something like that.
yeah. And you know, then the signature bond thing is may not be something that'll be available to you, because at least in this county, signature bonds are like, it's a 18-year-old kid has a marijuana joint or something, no criminal history. But it's a signature bond is not meant for people that are alleged to have actively gone out to commit a crime.
Oh, okay. So what is I'm qualified for? If I can make one.
You have a $2,000 bond right now. That's what you're qualified for.
$200 bond. So I get someone, if I can find someone to be able to post my bond, I had to pay $200 some odd dollars.
Yes, sir.
All right, but I don't have no one. I'm just on disability.
Okay, so Mr. Baker, the allegation is that you walked into a Home Depot and walked out with power steering fluid and saw blades that total $56.40. So I'm going to take the allegations as true. I'm going to take what you're telling me as true. What you're telling me is that when you walked into that place, those conditions were present.
Present. Right. I had doorbells that was already present. I was returning some items, but they told me.
Don't, Mr.
Baker,
don't talk about the facts of your case. This is being recorded.
Right.
This is being recorded.
Correct.
Give your lawyer a chance to help you.
Correct.
Okay. So, is there anything else?
No.
Okay. You're free to go back, Mr. Baker.
And the court date be on the 26th.
Yes, sir. Mr. Buford. Sir, you're charged with 1 count of theft by receiving stolen property. And it is charged, it appears to be as a misdemeanor. Bond is going to be set at $2,000. You're charged with 1 count of burglary. That's a felony offense, and bond is going to be set at $10,000. Your preliminary hearing date is going to be set for July 25th at 8:30 in the morning, courtroom 201. Most likely it'll be by Zoom. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, sir, you're free to go back.
Thank
You're welcome. Mr. Boys or Bose, B-O.
you. Foles. Good morning.
Mr. Bose, sir, you're charged 1 count of possession of a controlled substance with the intent to distribute. Bond is going to be set at $10,000. You're also charged with possession of a weapon during commission of a crime. Bond is going to be set at $10,000. Finally, you're charged with 1 count of knowingly driving a motor vehicle with a suspended or canceled registration. Bond is going to be set at $1,500. Your preliminary hearing date is going to be set for July 25th at 8:30 in the morning, courtroom 201. Most likely will be by Zoom. The date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir. You said the first charge was controlled substance. Is that different from possession of marijuana over an ounce? Because that's what I told I was charged with.
Yes. Well, it's not different. Marijuana is a controlled substance. And so the original charge was possession of marijuana with the intent to distribute.
Okay. Yeah, they told me it was possession of over an ounce. I didn't know it was intent to distribute the controlled substance.
Yes, that's what you've been charged with.
And you said what time is the court? 8:30 on the 20th?
8:30 in the morning. That they will get waived upon your bonding out. If you are in custody, you will be brought over by the sheriff's department. Okay.
Yes, sir.
Any other questions? Okay, sir, you're free to go back. Mr. Bryant. Mr. Bryant, sir, you're charged with 1 count of simple battery. Bond's going to be set at $4,000. There's going to be a stay away provision on this bond. The stay away from the Andra Johnson. Do you understand that, sir?
Yeah.
Your preliminary hearing date is going to be set for July 26th at 8:30 in the morning, courtroom 201. Most likely it'll be by Zoom. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, I would.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, sir, you're free to go back. Mr. Gate,
Oh, you want to continue Gates, Your Honor?
we're gonna continue Gates.
Would you like to see him or you want to continue?
Miss Mary, Mr. Gates, was that?
That's a continuance, Judge.
Okay, we're gonna continue Mr. Gates until.
Yes, Your Honor.
He'll be back tomorrow.
Next.
Mr. Gonzalez.
Yes, sir.
Mr. Gonzalez, sir, you're charged with several drug-related offenses. I've set bond on all of your offenses. So there are 4 violation of Georgia Controlled Substance Act charges. So with warrant number ending in 38, and this is for the person that is writing this down. $10,000. Warrant ended in 39. Bond is going to be set at $10,000. The warrant number ending in 40. Bond is going to be set at $10,000. And the warrant ending in 41. Bond is going to be set at $10,000. Charged with a misdemeanor use or possession of drug-related objects. Bond is going to be set at $1,500. That's warrant number ending in 42. And then you're charged with theft by receiving stolen property.
What is death by receiving?
I'm sorry, sir.
What is death by receiving?
Give me 1 second. I'll explain it to you. That warrant number ends in 43. Bond is going to be set at $10,000. So, Mr. Gonzalez, the theft by receiving, the allegation is that the vehicle that you were in was flagged by one of the cameras. They call them flop cameras. Cameras on the interstate, they read tags. And that's apparently how you got pulled over, is because the camera read the tag on the car and the car was coming back as a stolen vehicle. That's where the police officers encountered you. Then upon encountering you, they found all of these alleged substances in your vehicle. So theft by receiving is not, it's a situation where they have, the allegation basically is that you're in possession of property that you knew or should have known was stolen, and that you fail to return that property to the rightful owner. And that's the basics of the statute. Does that help you, sir?
Yeah.
Okay. So your preliminary hearing date is going to be set for July 25th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer, or do you plan on hiring your own lawyer? I'm sorry, Mr. Gonzalez.
You repeat your question, please?
I'm sorry, sir. I didn't understand you.
Can you repeat your question, please? Did you say something before that?
Oh, yeah. My question was, do you want me to see if you qualify for the appointment of a lawyer, or do you plan on hiring your own lawyer?
I wanted you to find out for me.
Okay.
Is it?
Okay, you do qualify, Mr. Gonzalez. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
No, Your Honor.
Okay, sir, you're free to go back. Mr. Hernandez.
Yes, sir.
Mr. Hernandez, sir, you're charged with one count driving vehicle on a suspended license. Bond is set at $1,500 for that. And one count of giving a false statement. Bond is going to be set at $5,000.
Okay, okay.
I'm gonna change that to $3,000.
Okay, yeah, because that's all I'm about to say. Back to your room. Go back to your room.
It sounds like you've been paying attention, Mr. Hernandez.
Yes, sir. Trying to get up out of here.
I'm trying to help you do that.
Yes, sir.
False statements is a felony offense. But I have it written as a misdemeanor. I'm going to place you on the felony calendar. Yes, the felony calendar. That'll be July 25th at 8:30 in the morning. However, if you bond out of jail today, that date will get waived and you'll get a new court date in the mail when the case is moved to the appropriate courtroom. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Hernandez. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
Okay, so the police lady said it was a false statement. The charge was a false statement, and I wanted to know what will make a false statement a felony.
What will make it a false statement upon?
What will make a false statement become a felony instead of a misdemeanor?
False statement is a felony offense. And that's something that I'll check later. But it's always been a felony offense. With a cap of 5 years as punishment. I'm unaware of any misdemeanor false statement.
I'm just asking because I did the false statement, but I ended up saying the truth, and I still got charged for my crime. So I don't know. I don't really get it, but okay.
Yeah, and that's something, and I made a notation because there's 2 people charged today with false statements that were written as misdemeanors. And the reason I know this is that there was a person charged with driving under the influence of alcohol, and that person, when asked, pulled over and asked, said, no, I wasn't drinking. But then later in the conversation said, I was drinking. Now,
yeah,
or I had a drink. Now, driving under influence is a misdemeanor offense, but they charged that person as a felony under false statements. And it went all the way up to the Georgia Supreme Court. And they said, well, yeah, it's a felony. And if you're in the middle of an investigation as a police officer and a person gives you incorrect information, that can be the basis of the felony offense charge. So I'll see if there's been a change.
Okay.
And if there has been, of course, you and the other young lady, your cases will stay as misdemeanors and go through misdemeanor court.
Okay, yes, sir.
All right, you're free to go back.
Okay, thank you.
Mr. Jones.
Morning.
Morning, sir. You're charged with one count of failure to yield the right of way when entering a roadway. Bond is set at $500, and that's set by statute. You're charged with one count of driving under the influence of alcohol. That's a misdemeanor. It's bond set at $5,000. And you're charged with the misdemeanor. Well, it's a felony, but it's a simple possession charge of possession of a controlled substance. Bond is set at $3,000. That's total bond of $8,500. You're gonna have a preliminary hearing date set for July 25th at 8:30 in the morning, courtroom 201. Most likely will be by Zoom. That date will get waived upon your bonding out, and you'll get a new court date in the mail. It says you refuse to fill out the form. Does that mean you're gonna hire your own lawyer?
Yes, ma'am. Yes, sir.
Okay. Do you have any questions of me?
I have a bond of 8,000, what again? I'm sorry.
$8,500.
$8,500.
Yes, sir.
That's effective today. I can bond out today. For the bail bondsman, or can I pay the whole thing?
I'm sorry. Would you repeat that question?
The 8,000, is this for, I can bond out today with this?
Yes, sir.
Okay.
It'll and it will be a little higher than what I've told you, because the sheriff's office is required by law to add fees from the state of Georgia to the bond amount, and I don't have the fee schedule, so they will add the fees that they're mandated by law to add to this amount.
Okay. I have a question.
Yes.
During this conflict, the lady that I hit was one of the sheriff deputy's wife, which it was just an accident. It was nothing dangerous or anything. Can I get his badge number of the report you have?
So whatever report that is written about this is a public document that you will have access to.
Okay, I'll go there.
Okay.
Mm-hmm.
Anything else, sir?
Oh, thank you.
Okay. All right. Mr. Fitzpatrick or Kilpatrick.
How you doing?
I'm doing well. Mr. Kilpatrick, the top charge is kidnapping. I cannot set bond for that charge at this hearing.
Can you hear my side of the story, sir? Please.
Mr. Patrick.
Now, like, sir.
Mr. Kilpatrick, let me stop you, and then I will assist you as best I can, okay? Because I'm not the person that wrote these charges out, I'm not the person that can have what essentially will be a trial, in the sense that got both sides in here telling me what they think and what's going on. And then,
yes, sir.
So just listen, please.
Why you got somebody? This is my ex-girlfriend. My ex. We've been together 3 years, bro. And this girl will lie about
Mr. Kilpatrick, First, I'm not your bro.
Yes, sir.
Second, I started the conversation with telling you, you can speak to me for the next 3 hours and I cannot do anything for you.
I'm saying, but why would the officer write kidnapping and the child is on the scene when he pull up at the store? I ain't take the baby. The baby was in her hand. So how can I get a kidnapping charge?
I don't know. I don't know. That's where the adversarial process kicks in.
Yes,
Meaning there's both sides. And I can say, Mr. Kilpatrick has a good question. Why was he charged with this when the baby was in the hand of the mother?
And when the police arrived on the scene.
Mr. Kilpatrick, is there anybody for me to ask that question to right now?
But is she in there? I'm saying, sir, I ain't been in trouble in over 15 years. You looking at me like I'm lying to you, like I'm not gonna tell you the truth.
No. I don't know you, Mr. Kilpatrick.
Yes,
I expect everyone to tell me the truth. And
Yes,
I treat everyone as if they're telling me the truth.
Yes,
Just
sir.
as I'm telling you the truth.
Yes,
that
sir.
I can't do anything related to this charge today.
Yes, ma'am. I mean, yes, sir. But listen to me. Can you listen to me? This girl is lying. I got this girl out 4 months ago on bond about domestic violence. And at the end of the day, this girl been going through the changes with me because she don't want to break up. So she would lie about anything. The baby was there when the police got there. Tell me this thing.
He's only here to give you information. I told you this earlier. He cannot do anything about what you're being charged with. Let him give you the information so that we can move on to the next person. You're taking up too much time.
So I can explain myself.
No, you can't explain nothing until you talk to the person.
Mr. Kilpatrick, do you want me to appoint you a lawyer?
Yeah.
Yes, sir.
Yes, sir. This some bull, man. Cause
Mr. Kilpatrick, I don't know the lady. That's someone.
My girlfriend. My ex.
Stop interrupting, man. All right. Let the judge call. Okay.
Mr. Kilpatrick, I'm gonna tell you this one time. If you keep doing what you're doing, I'll bring you back tomorrow and we can start over. It's just, I don't know why. When I tell you I can't do anything for you, you just keep talking like I can. And you not trying to just listen to what I can do for you. I can appoint a lawyer to represent you. I can set court dates. You can hire your own lawyer that may be able to go and pull through the stuff to show that you've been wrongly charged and wrongly accused.
Yes, I understand, man. I just want to tell you, bro, this girl is lying, man. She wrote a statement on me.
Mr. Kilpatrick, she's a liar. She's a person that would lie on a person that put her in and put him in jail. Okay, what's the next step?
Somebody that's delusional and somebody that's just got out of jail 4 months.
What's the next step? What's the next step?
Okay, sir, you can look through her record. This girl, we don't been through the changes already. She don't call the police plenty of times.
Mr. Kilpatrick. Mr. Kilpatrick. Okay, deputy, let's bring Mr. Kilpatrick back.
No, I just want to. Okay,
I'm bring you back tomorrow. I'm bring you back tomorrow because you apparently don't believe me when I just told you some stuff.
Yes, sir.
You want to keep telling me what I need to know. But sir, I'll see you tomorrow. I'm gonna see you tomorrow, Mr. Kilpatrick. Go, that deputy, let's take him away. I'll see him tomorrow.
I'll take a seat. Come on, Pounds.
Something, bro.
Price, you're next.
Good morning, Your Honor.
Good morning. Tell me your name, sir.
Sir,
Tell me your name.
Jeffrey Pounds. Pounds.
Mr. Pounds. Deputies, David Miles.
Your Honor.
I didn't get a warrant for Mr. Miles, and he wasn't on the calendar. So I guess he'll be on the calendar for tomorrow, and I'll just make a note for him to be on the calendar tomorrow.
Yes, Your Honor.
Okay. Mr. Pound, sir, you're
Yes, sir.
charged with 1 count of driving on a suspended license, bond is set at $1,500. You're also charged with 1 count of driving on an expired tag, bond's gonna be set at $500. Because these are both misdemeanors, your preliminary hearing date is gonna be set for July 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir. I sure will, Your Honor.
Okay. Okay, sir, you do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir, no.
Okay, you're free to go back, Mr. Pounds.
Thank you.
Mr. Price,
Yes, Your Honor.
Mr. Price, sir, you're charged with 2 financial related crimes. One is financial transaction card theft. Bond is going to be set at $10,000. And one is financial transaction card fraud. Bond is also going to be set at $10,000 for a total bond of $20,000. These are misdemeanor offenses. So bond is going to be, preliminary hearing date. It's going to be set for July 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer? You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, sir, you're free to go back. Mr. Reed.
Yes, sir.
Mr. Reed, sir, you're charged with 1 count of family violence battery. Bond is going to be set at $5,000. There's going to be a stay away provision on the bond to stay away from a Crystal Inslee. Do you understand that, sir?
Yes, sir. Mr. Florio, they come today?
I'm sorry, sir.
Mr. Florio?
Is that your lawyer?
Yes, sir.
He's not on.
I mean, I had time myself, man, I saw you, but I didn't call him before I came.
Okay. So I'm gonna put on here that Mr. Florio is your lawyer. The preliminary hearing date will get waived upon your bonding out. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. Roy. I'm doing well. Mr. Roy, sir, you're charged with 1 count of criminal trespass. Bond is going to be set at $1,000.
Yes, sir.
Misdemeanor offense, you're going to have a preliminary hearing date set for July 26th at 8:30 in the morning. That date will get waived upon your bonding out. You'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
So, yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me, Mr. Roy?
Sir, no, sir.
Okay, you're free to go back. Mr. Royal. Mr. Royal, sir, you're charged with 1 count of battery, 1 count of murder, and 1 count of possession of a weapon during the commission of a crime. Cannot set bond on the murder offense. And so I have set a $5,000 bond on the battery, family homicide, homicide, family violence. Bond is going to be denied on the malice murder charge pursuant to Georgia statute 17-6-1. And possession of a weapon during the commission of a crime, bond is going to be denied on that charge. Do you want me to appoint a lawyer to represent you?
Yes, sir.
Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. Sutton.
Yes, sir.
Mr. Sutton, sir, you're charged with 1 count of possession of a weapon by a person who should not have the weapon. Bond is going to be set at $5,000. This is a misdemeanor offense. So your preliminary hearing date is going to be set for July 26th at 8:30 in the morning. Courtroom 201, that date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
One question.
Yes, sir.
How did I get charged? My mom said on her guns and they traced them back. Those are my mother's weapons. They're in her name and her vehicle.
So were you the only person in the vehicle?
No, sir.
Were you the driver of the vehicle? I'm sorry, you said yes.
No, sir.
Who was driving the vehicle?
Relative.
Who was that?
My brother.
And your brother's name is what?
Jacquees. Thomas.
Thomas.
She just called me and told me they said she could come and pick him up tomorrow. She was on the phone with the officer at the scene telling her that those are her weapons and her name.
All right. I'm going to dismiss this charge, Mr. Sutton.
Thank you.
Judge, you're gonna dismiss it?
Yeah, I'm gonna dismiss it because I just looked at the next person, Mr. Thomas.
And they charged him with the same thing.
Well, they didn't charge him with the same thing. They charged him with possession of marijuana less than an ounce and terroristic threats. But there's no identification as to who is in the vehicle and who's driving. And as I look at it,
Vehicles, not even
based upon what Mr. Sutton just told me, It is poorly written. All right, sir. It's going to be dismissed. Mr. Thomas. So, you're charged with possession of marijuana less than an ounce. And the allegation is that the alleged cigarillo fell out of your pocket when you got out of the car. So that's a misdemeanor offense. Bond's going to be set at $1,500. And the terrorist threat and act allegation is that you told the officer you're coming for him when you get out of jail, and that's sufficient for the terrorist threat or acts charge. So you're going to have a bond set at $1,500 for the possession of marijuana and $3,000 for the terroristic threat charge. Your preliminary hearing date is going to be set for July 26th at 8:30 in the morning. Courtroom 201, most likely by Zoom. That date will get waived upon your bonding out, and you will get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Thomas. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. Wright.
How you doing, Your Honor?
I'm doing well, Mr. Wright. You're charged with armed robbery and false imprisonment. I cannot set bond on the armed robbery charge at this stage. So bond is going to be denied pursuant to Georgia statute 17-6-1. You're also charged with false imprisonment, and I denied that charge just so that both, or denied bond on that charge, just so that both can be heard and decided at the same time.
May I also say something, Your Honor?
Yes, sir.
I didn't know I had a warrant for this matter, because if I knew I had a warrant for this matter, I would have came to court. And if you can explain my charges, because when I read, I am falsely accused from someone that I dated. And yeah, she's falsely accusing me because I no longer wanted to deal with her.
Because you did not want to do what?
I don't deal with her. Somebody I dated that gave me gonorrhea and gave me STD, being honest. And I just found out that I had a warrant, at work. I'm having a baby on the way, so I definitely can't lose this job. It's just me. I don't have any family here. I have my mom, I don't have my dad. It's just me.
Okay, so the warrant was issued on June 2nd of this year.
Because I didn't even know. I didn't have anything. Notice came in the mail, nothing.
I understand. So, and I'll explain it to you as short as I can. Certain people that voted got their legislators to carve out exceptions to what a judge can and cannot do. So you could be the nicest person in the world, and I still can't set you bond on this charge at this stage.
Even if somebody's falsely accusing me.
Well, the thing is, the only way you determine if it's falsely accused is that you have a hearing as a judge and you bring everybody in and you sit them down and you put them up on the stand and you have them swear to tell the truth, the whole truth, and nothing but the truth. And after listening to the evidence, the judge makes a determination as to who's telling the truth or who's not.
Yes, sir. No,
Every trial has prosecution and defense. Somebody wins, somebody loses.
yes, sir.
And that's after people listen. But listen to me, sir, please.
Yes, sir.
That's after people listen to the evidence. If you have facts and evidence to back up what you're telling me, your best bet is as quickly as possible is to hire an attorney so that that attorney can be knocking at the district attorney's door tomorrow saying, I have proof that my client didn't do this. And based upon that proof, things will be possibly reconsidered. And honestly, I don't know. Because the district attorney, she gets to make her own decision about how she feels about the facts of the case. But again, she's an elected official, just like everybody else.
Now, is it possible you can explain to me the charges real fast, and if I can also qualify for counsel?
I will.
I'm definitely interested.
I will appoint a lawyer to represent you, and I will explain to you the facts as laid out in this warrant. It says on April 9th that with the intent to commit a theft, you took a black, said black/white iPhone X, the property of Michael Jones, from the immediate presence of Michael Jones by use of a knife. That you met Michael Jones at 5100 West Fayetteville Road, College Park, Clayton County, Georgia, Country Inn and Suites. And during this meeting, that Michael Jones was robbed by you and an unknown female for her iPhone and her car keys at knife point. Says Jones tried to lock her door and leave the location before the incident. But you unlocked the door to allow the unknown female to enter the vehicle. It says on April 11th that this officer, whose name is Brushan Washington, responded to 5100 Fayetteville Road, Country Inn, in reference to possible video footage on 4/9/2022. The suspect vehicle, a Charger, arrived at the incident location. The vehicle backs into a parking space on the south end of the parking lot. The headlights for the vehicle turn off about a minute later. Suspect 1, which they're alleging is you, exits the vehicle and stands in the parking lot. That it says they loiter near an SUV and the lights for the Charger turn on at 0009 hours, which is 9 minutes after midnight. The vehicle stays parked, and at 10 minutes after midnight, Jones arrives. She stops at suspect 1, and he gets into the passenger side of the vehicle. She then backs into a parking, and it says spaces. So I'm assuming they're saying Michelle Jones, even though they've written it as Michael Jones. Suspect 2 exits her vehicle at 12 minutes after midnight and approaches Jones' vehicle. After suspect 2 arrives at Jones' vehicle, a short while later, the vehicle's brake lights are illuminated several times. At 13 minutes after midnight, the vehicle pulls forward as if it were leaving, but then stops. The brake lights are illuminated a few more times and the headlights turn off at 17 minutes after midnight. Both suspects exit Jones' vehicle and return to the still running Charger. They leave the location north of West Fayetteville Road. Jones is seen running into the hotel after the suspects leave. On April 18th, I spoke with, says Michael Jones, in reference to this case. It says she advised, met Wright on a dating app, POF, in February. She advised they were dating and had several meetings that did not end in a robbery. She advised he would come to her Airbnb, and she was even went to what she believed is his uncle's house. Jones advised Wright was robbed twice before, once in DeKalb and once in Atlanta. Well, she said Jones has robbed twice before, once in DeKalb and once in Atlanta. She advised the suspect threatened her and her family after the first 2 incidents. She advised she did not want him to do anything, so she did not press the issue. Jones met Wright at Country Inn to retrieve the money he had previously stolen. Jones realized when suspect 2 walked up to her car, something was not right. When she locked the door, Wright unlocked the door as she tried to leave the location. Jones stopped the vehicle. Suspect 2 opened the door, produced a knife, and Jones held both suspects. They took her phone, and Jones advised they transferred $1,200 from her bank account using her Cash app while she was being held in a chokehold. She advised Wright stole money in the same way in a previous incident. Jones advised she knows Wright well. I prepared a photo lineup for Jones to review, and she selected Wright.
Thank you, Your Honor.
You're welcome.
And now, you said that I will be appointed a lawyer or counsel?
Yes, sir. Yes, sir.
And when will be my next court date?
Your next scheduled court date is July 25th at 8:30 in the morning, and that'll be by Zoom.
Okay. Is there anything else I may need to know about like my lawyer and stuff, or?
It's gonna be from the public defender's office. So most likely it'll be either Tiffany Pleasant, Javard Rogers, or Miss Hill, I can't remember.
Now, how can I get that? How can I get that information? Will they contact me by them coming here to meet with me, or can I get you?
They will. The way that things are going now, through my understanding, is because of the COVID related thing. They will make an appointment for you to meet with them over the computer.
So they will. So they'll contact me before the court date, correct?
Yes.
All right. Thank you, Your Honor.
Okay, sir. You're free to go back. Yes. These are the people who are alleged to be fugitives?
Yes, Your Honor.
Okay, give me 1 second.
Oh.
Okay, gentlemen, I'm gonna need you to help me out. I have a Mr. Crocker and a Mr. Fontaine and a Mr. Lucas.
Yes, sir. Yes, sir.
Okay, so I see one person.
Mr. Crocker. Mr.
Okay. Crocker, Lucas, and then next to Mr. Lucas is Mr. Fontaine. Okay, so the three of you are in a position where you have the same rights and privileges as I discussed earlier with everyone, but you are in a separate situation in the sense that you're being alleged to be a fugitive from justice. And what that simply means is that there's a warrant for your arrest out of another state. So, Mr. Crocker, the allegation is that there's a warrant for your arrest out of Jefferson Parish. Wait a minute. Nope. Sorry. That says Mr. Fontaine. Okay, Mr. Crocker, I have two warrants for Mr. Fontaine. No, well, it's the same thing. Mr. Crocker.
Yes, sir.
Have you gone through the first appearance proceeding for the driving?
Yes, sir. I had moved on for that yesterday.
And that was yesterday. Okay. Okay. All right. I'm gonna put Mr. Crocker to the side for the moment because I have two warrants. And for Mr. Fontaine, I don't have two warrants. I have two copies of the same warrant for you. So I'll start with Mr. Fontaine. Ms. Fontaine, the allegation is that you're wanted out of Jefferson Parish for possession of marijuana and resisting an officer, and they have said that they will extradite. For Mr. Lucas, it says that you are wanted out of, let's see. Out of Seminole County in Florida for probation violation and fleeing to elude.
Can I ask you a question? Can you tell me the date of that warrant was issued?
Let's see. I have the warrant number. I don't have the date that it was issued, and the warrant number is 191319 CFA. So, and I'm going to get back to you, Mr. Crocker, in a minute, but for all three of you, the process that's employed at this point, you have two options. One, if you believe that you are not the person named in the warrant, or that the warrant is making an allegation for a charge that you don't believe that offense is a valid charge, you can challenge it. And if you tell me today that you want to challenge it, sometime between now and the next 90 days, there'll be a hearing set for a judge to determine whether, one, you are the person named in the warrant, and two, whether those charges actually exist. At the end of that hearing, the judge will, if the judge finds that the warrant is valid and the charges do exist, judge will sign off on a writ that will allow the requesting jurisdiction to come and get you. Upon the judge signing that warrant, you will have a statutory period of 30 days up to 60 days for that jurisdiction come and get you. And if they do not come and get you within the requested time, you'll get released out the front door, but the warrant will not go away. And so what that means is that you could be released out the front door in 5 minutes. You encounter another law enforcement officer, and that officer runs your information. You're going to be taken into custody, and the process starts all over again. If you believe you are the person named in the warrant and that the warrant exists or has charges that exist, you can waive that whole process. And if you waive that process today, then that 30 to 60 day window begins to run today. And if they don't come and get you, the same thing will happen. You'll get released out the front door, and the warrant will still exist. But if you encounter a law enforcement officer, then that officer will take you into custody, and the process will start all over again. Am I making sense to you guys so far?
Yes, sir.
Are there any questions so far? I'll start with Mr. Lucas. Are there any questions so far?
There wasn't a date on there when the warrant was issued?
Or you, Mr. Lucas? Again, the only thing I have is warrant number.
Can you read it off for me again, please?
191319 CFA.
Thank you.
And it says it's a probation violation warrant.
I understand.
And so I would presume if you're able to contact your probation officer, you may be able to clear it up.
Yeah, because when they arrested me, they said it was December, they got it in December of 2021. But I done been to court in Florida 3 times and I got my probation reinstated. So I was just asking, did you have a date on it? That's all.
Which, Mr. Lucas, what you just said brings up a good point that I neglected to say. For the 3 of you, I would encourage you to, if you don't have a lawyer, get a lawyer in each of the jurisdictions. Because with the COVID thing going on and all that kind of stuff that I've seen courts be welcoming to waiving a warrant or rescinding a warrant and putting a person back on the calendar and moving that stuff forward. So it may most likely will be in your benefit to do that. And you could be in a situation where you don't have to go anywhere. And they will act on your behalf. I've had situations where a person appeared before me on a Wednesday for fugitive from justice warrant, and they hired a lawyer. And by Friday, I was receiving paperwork where the lawyer had gotten the judge to sign off on withdrawing the warrant. And so I signed off on it and the person was released. So you don't have to sit here depending on, your circumstance, but you will have to try to get some movement, and it'll have to be in the jurisdiction where this stuff is pending. Mr. Fontaine, sir, do you understand what I've said so far?
Yes, sir.
I got one question.
I'm going to ask Mr. Fontaine, do you know whether you want to waive or request a hearing?
Waive me and sign these papers, right? I want to sign these papers.
Okay. Mr. Lucas, do you know whether you want to waive or have a hearing?
I'm gonna sign these papers. I'm gonna waive. I'm gonna sign.
Okay. And Mr. I'm sorry. Mr. Crocker. Do you know whether you want to waive or have a hearing?
I'm on the way. Them come get me. Yeah, waive. Sign paper. I'm trying to waive, y'all.
Okay. Well, each of you sign the waivers and they'll send it to me and I'll sign off on it.
Sign on 7. Use the shovel. I got a question right quick. Yes.
John.
Yes, sir.
Will my New Orleans lawyer be able to talk to me from this jail, like a video visit?
The short answer is I don't know, but from a technology standpoint, I can't see why the lawyer couldn't. And that's just something that I don't have experience with, but I do know that the people from the public defender's office, they'll set up meetings. And I think, and Deputy, if you're in earshot, is that sort of like a service that is set up for basically everyone? If they have a client in the Clayton County Jail and the lawyer wants to try to speak to the client?
They're all able to meet via video visit.
Okay. Okay. So it would be, tell your lawyer to contact the Clayton County Sheriff's Department to set up a video visit.
Yes, sir.
And then they will give the lawyer the information that the lawyer needs.
Yes, sir. I appreciate it.
Okay. Let me ask one question. Has Mr. Kilpatrick gone back?
No, Your Honor, he's still in the courtroom.
Okay, let's bring Mr. Kilpatrick back up.
Yeah.
Mr. Kilpatrick, sir, I am not your enemy. I am here to try to convey to you what is going on. I understand that you're in a position where from your position, the person is treating you in a very poor way. Just from a statutory standpoint, I cannot set a bond for the kidnapping charge at this stage. Matter of fact, hold on. Let me.
What's on this? What's the question?
So the thing that's causing the technical issue with you as it relates to this kidnapping charge is the prior, even though it was on the first offender, the prior conviction for aggravated assault.
From my past history.
Yeah, there's aggravated assault, kidnapping, burglary are offenses that if you have a prior conviction for either one of those.
No, 20 years ago, almost 20 years ago though, sir. I'm 17 when that happened. 17, I'm 30. 31 now. I learned my lesson. That's first offender, that's old. So y'all basically trying to go off my record to for this present case, right? Right or wrong? Because that's what it seemed like.
Let the judge talk. You're gonna get continued again.
So the answer to your question is I didn't write the laws that I have to follow. If I break the law, what kind of respect do you give a judge that judge breaks the law? Because you may one day you're like, well, hey, yeah, judge is on my side. But then the next day, the judge is not on your side. And that judge just break the law based upon whatever that judge wants to do. That's not how the system is supposed to work. What I'm trying to tell you, Mr. Kilpatrick, is that there's nothing stopping you from getting a bond tomorrow.
Yes, sir.
You got to go through the district attorney's office. And that's the way that they have prepared everything and said everything. That they're like, hey, I don't want Judge Gardner. He may be, soft-hearted, and he's going to just give bond to people. And we don't even know. We don't want Mr. Kilpatrick out on the street and he go before Judge Gardner. Judge Gardner sets him a bond. So they got the law changed that says I cannot do it. So I can set you a bond today and I'll be out of a job tomorrow. But there are things that you can do to deal with this issue. First thing is not to get mad and argue at people that are telling you that the sky is blue. And it's like, well, the sky is blue. Let's figure out what we're gonna do about that. So I am trying to get you in a position where you can do what you need to do to get yourself out of this. And I would, if a person's lying on me and I go to jail, I do whatever I can to nail that person to the wall. From a legal standpoint, take everything they have, because you just can't treat people that way. What I would caution you, Mr. Kilpatrick, is don't kill the messenger. Don't get upset about the person who's giving you the bad news. I don't have any, I have no hatred whatsoever in my heart towards you. I don't know you. But I need you to understand that right now you have these charges. I cannot set bond on the kidnapping. I set bond on the cruelty to children at $3,000 and on the battery charge at $5,000. If I could set bond on the kidnapping, I would have set bond on the kidnapping. It's a stay away provision on the bond and stay away from a Kamari Troutman. You're going to have a preliminary hearing date set for July 25th at 8:30 in the morning. But I know I'm going to appoint the public defender's office to represent you. If you're in a position where you can hire a lawyer, I know that is a significant drain on finances, but the lawyer may be able to get before the district attorney's office sooner. The lawyers in the public defender's office, they're very good lawyers. They've been practicing for about as long as I've been practicing law. And they deal with the person who handles the preliminary hearing. They deal with her on a daily basis. So if if there's insight that your case should get, I trust them in being able to tell the prosecutor before any court date that, hey, this is what happened in this case, and this is what you need to look at, and this is what I have. Because and I think next week I'll be doing it when I'm sitting and I'm doing warrants, and I'll get stuff that comes across where it's like, I'm not the judge just sitting, but they've been working. And when they reach an agreement, they send the stuff off for the judge to sign. And I've never not signed anything that's come across. So I feel bad for you being in this situation, but I just need you to understand, sir, that people are willing to work and help you, but people are not willing to be yelled at.
Yes, sir.
Okay. So I've appointed the public defender's office to represent you, sir. So you are free to go back, and with Mr. Kilpatrick being done, that's the last case we have for today's calendar.
So, July 25th, when I go to court.
That is the next scheduled court date. But as I said before, they can work on your case and have a consent. And generally what happens is the prosecutor will agree to consent to a bond on a kidnapping charge that I couldn't set, and then you'll agree to a waiver, and the case just gets sent over to Superior Court for whenever it's indicted. But you get to get out of jail and go about your life and prepare yourself and for your the defense of your case. Okay. All right. So Mr. Kilpatrick can go back, and that completes today's calendar. And I'll see everyone tomorrow.
Your Honor, before you log off.
Yes, sir.
Donald Jones would like to be considered for court-appointed counsel instead of refusing court-appointed counsel.
Donald Jones.
Yes, Your Honor.
And bring Mr. Jones up.
Singapore line. And now, Singapore line.
Yes, sir.
Mr. Jones, are you currently working?
No, sir.
Keep quiet.
Did you say no?
I'm not.
Okay, going to appoint a lawyer to represent you. Is there anything else, Mr. Jones?
No, that after the moving speech you gave, I said, well, I would like to try.
I'm sorry, sir.
I said, after the moving speech you gave to the other young man, I said, well, maybe this is worth trying. I would like to try a public defender.
Let's go.
Well, and you need to be cooperative with them, because they will contact you to set up a meeting. And it surprises me, because they'll come in and say, well, I set up like 2 meetings to try to meet with the client, and the client didn't come on. So just be cooperative.
Yes, sir.
Okay. All right. You're welcome. Okay, is there anything else, Deputy?
No, Your Honor, that'll be all.
Okay. I'll see you all tomorrow.
Yes, Your Honor, you have a great rest of your day.